begins, how many people are here to testify on the next bill? Spike, are you an opponent? Yes. Okay, very well. Thank you. Senator Hilkemann, welcome back.
Thank you. Good afternoon, Chairman Lathrop and members of the Judiciary Committee. I'm Robert Hilkemann, R-O-B-E-R-T-H-I-L-K-E-M-A-N-N, and I represent District 4 in West Omaha. LB496 is a bill known across the country as Katie's Law. I became aware of Katie's Law in 2015 while attending an NCSL meeting. It was the first time that I had heard of obtaining DNA on felony arrest. I heard the testimony of James Hilkemann, a man who'd spent 18 years in prison falsely accused, who was exonerated with DNA evidence. I learned about the powerful tool that arrestee DNA could provide for our local law enforcement agencies to help solve unsolved crimes, help in solving current cases, and how it has prevented crime from occurring. And most importantly, it exonerates arrestees who are found innocent by DNA evidence. If there were a way to guarantee we convict the guilty and exonerate the innocent without fail, we would all be for it, would we not? Realistically, I know that can't happen, but I do believe this bill moves us closer in that direction. I believe that LB 496 is a bill that will help Nebraska be smart on crime. When I first heard about it, I thought it was a good idea. After studying it and visiting with various law enforcement groups and talking with many of my colleagues over the years, I have become passionate about this Katie's Law. I first introduced this bill in 2016. I believe that Senator Pansing Brooks and Senator Moorfield, I think you were on the committee at that time. I carefully reviewed the objections that were raised in 2016, and I believe that this version of the bill that we're presenting today is a better bill. The bill accomplishes the following. It adds that individuals arrested for crimes of violence provide a DNA sample under the DNA Identification Information Act. Secondly, it defines crimes of violence and enumerates those specific crimes currently in statute. It specifies that the DNA sample will be collected by a law enforcement official at the receiving criminal detention facility during the booking process. It specifies that such DNA samples shall be collected by buccal cell collection kit, which is the swab of the inner cheek of the mouth. The bill provides for expungement upon request if the person was not charged with a crime of violence for which the person was arrested within 1 year after the arrest. All criminal charges filed as a result of an arrest for a crime of violence were dismissed without prejudice, and any statute of limitations has run. The person was acquitted of all criminal charges filed as a result of the arrest for a crime of violence. This requires the Nebraska State Patrol on or before February 1st of 2022 to adopt and promulgate rules and regulations regarding acceptable documentation a person may submit a request for expungement. This requires the Nebraska State Patrol to purge all DNA records and identifiable information in the database pertaining to the person and destroy all DNA samples from the person upon receipt of the documentation established in the adopted and promulgated rules and regulations. How this would work in practical matters: when an individual is arrested for one of the crimes of violence listed in this bill, so they have their photograph taken, fingerprints taken, a swab of the inner cheek of the mouth will be collected for DNA at the same time. The DNA is then processed in a CODIS certified laboratory. In Nebraska, that is our State Patrol Crime Lab. Officials then send the results of that DNA test into the federal DNA database called CODIS. The CODIS will then search 20 markers of the DNA for matches. The CODIS will only notify law enforcement if there is a match with another specimen in the CODIS pool. Then and only then is the identity of the person given to law enforcement. CODIS does not match for race or other characteristics. Only the sex of the person can be determined from these markers. If the arrestee is found not guilty of the charges, they can have their information removed from the system. The U.S. Supreme Court in Maryland versus King in June of 2013 ruled that the buccal swab is on par with taking an arrestee's fingerprints and does not violate one's Fourth Amendment constitutional rights. Here to testify as a proponent today is Ms. Jan Sepich. Jan is the mother of Katie, for whom this law is named. She has made this her life mission to get Katie's law in every state in the Union. Jan has been working on this issue for many years. She has been successful in seeing this law enacted in 31 states, including our neighbors of Kansas, Colorado, South Dakota, and Missouri. I know she is looking forward to sharing her story with you and will be happy to answer any of your questions. This is her second visit to the Nebraska legislature to testify on this matter. I am so grateful for her willingness to travel all the way from New Mexico to appear before you today. Because she truly is the expert in the room, I want to ensure that she has adequate time and testify and answer the questions that you have. I want to acknowledge that there will be some opposition testimony here today, as there was in 2016. My hope is that we can work together on any way that we can strengthen and improve this bill to advance it to general file this year. I think there are many options to address the physical note, which is included, such as outsourcing the testing. There are federal grants that will help pay for the DNA processing. My best assessment is that the physical note is estimated about $157 per test. We know that the national average is $35, so I don't know exactly, as you well know, about physical notes in this department. So I think we need to take a look at that as well. JN will probably be able to address some of those information as well. We had several testifier proponents from the Attorney General's office to the county attorneys that in the last 24 hours, I think they've sent you testimony, and so they will not be testifying here in person today, so we have the opportunity for you to spend more time with the person who's been passionate about this for her whole life. When I think of the families out there waiting for answers, for the victims deserving of justice, for the innocent people who deserve to be freed, and for any life we can save in the future, I only can become more passionate about this issue. I thank you for consideration, and I would be happy to answer whatever questions I can at this time.
Okay, Senator Bryant.
Thank you, Chairman Lathrop. Thank you, Senator Hilkemann, for bringing this bill. So to be clear on how the system works today, the state of Nebraska maintains this CODIS network on individuals that are convicted of a crime in Nebraska. And what this bill would do would be to add the DNA information of people that are arrested at that time. And that database is maintained off network from other databases. Would that be correct?
They are arrested for their DNA is for the crimes that are listed in this, the more serious crimes, not just being arrested for running a stoplight.
Yeah, I saw the list.
So it's for the serious crimes, and yes, it's maintained by CODIS, which is the federal DNA.
But that system is set up intentionally offline, in a sense. I mean, it would be on a computer like nobody else would have access to.
That's
I think
correct.
you said it was one individual. And it sounds like the State Patrol, it seems a little strange. Usually when we get a fiscal note that's high, it's because they're against it. But you're saying the State Patrol really does support this?
2 years ago, the Omaha Police Department, I can't say, I'm not going to speak for the State Patrol. If they have not, they're not here today.
Okay. All right. Thank you.
Senator McKinney.
Thank you. Looking at this bill, one thing that gives me pause is individuals that are under criminal investigation. How would that work? So, say a crime happens and there's multiple potential suspects. Does all those individuals present a DNA sample if this bill was passed?
I'm sorry, Senator.
Sorry. My question is individuals that are under criminal investigation, and I'm just curious to know that, so if a crime happens and there's multiple suspects, would all of those individuals be subject to giving a DNA sample if this was passed?
Well, I think, no, it's only on arrest. If they were, just because of investigation, unless a person's been arrested for the crime, they would not, just being a suspect, unless they're arrested or be arrested for the...
So you have to be arrested. All right. Thank you.
Okay.
I don't see any other questions. I do want to, so we've observed the 3-minute rule. I know you have somebody that came from a long ways away. We'll have her testify for 3 minutes. I'm confident there will be an opportunity with questions to testify or to speak further, but we have to observe the 3-minute rule.
Okay.
Okay?
You bet.
Very good. Thank you, Senator. We will take proponent testimony at this time. Good afternoon. Welcome.
Thank you. Good afternoon, Mr. Chairman, members of the committee. Thank you so much for allowing me to testify today. My name is J-Ann Sepich, J-A-Y-A-N-N-S-E-P-I-C-H. You've been provided a handout, and I see it hasn't gotten to all of you yet. I want you to look at these numbers on the front of this handout. So what are these numbers? Super lottery numbers? Offshore bank account numbers? No. But these numbers offer more hope, more promise than even winning $1 million, millions of dollars in a lottery. Because these numbers can stop serial rapists and murderers before they can offend again. I know intimately the pain that can result from violent crime. My daughter Katie was a 22-year-old graduate student when a man she had never met very brutally kidnapped her, raped her, sodomized her, beat her, killed her, and set her on fire. It's numbers like these that finally identified her killer and put him in prison where he could never hurt another young woman. This numerical profile is the only personal identification that goes into CODIS, just those numbers. These numbers identify only 20 locations on the genome out of over 3 billion, and they were specifically chosen by genetic scientists because they are non-coding. They offer no genetic information whatsoever. Even a PhD in genetics could not tell anything about a person from these numbers. And what's more, there are no names in CODIS, no social security numbers in CODIS. There's a specimen ID number that's only matched back to the person's name after there's a match to crime scene information. Those numbers that are on your handout are that's actually my DNA profile. I had it run. That's my profile. And I'm so confident there's no information that I printed on the back of my business card and handed out to perfect strangers every day. More than 25 million Americans have spit into a little tube and sent it into companies like Ancestry.com and 23andMe. And when they do this, they're providing those companies with their whole genome, all 3 billion markers. And what's more, they're giving those companies ownership of that DNA. Contrast that to CODIS. which only takes a little sliver of the DNA with no genetic information. The CODIS system is working. It's working incredibly. 31 states already have this. As Senator Hilkemann said, a lot of your neighbors. I would like to tell you my home state of Nebraska has almost the exact same population as my home state of New Mexico has almost the exact same population as Nebraska. And New Mexico has aided in a total of 5,433 criminal investigations. Nebraska's total is 894. And I believe the main difference is the arrestee DNA system. Also in New Mexico, when crime scene evidence is found and uploaded into CODIS, they get a match to a name 50% of the time on the first run. That's the power of those 40 numbers. I'm not afraid of having my DNA in CODIS. I am afraid of the pain and the suffering that it causes victims, how it shatters families. So much can be done with just these numbers. I want to thank you so much for your time, and I hope you will ask me any and all questions that you might have.
Senator Geist has a question for you.
Yes, thank you for your testimony, and thank you for coming all this way. My question is, since this is only a small number of all the numbers that it could code, is there a danger of misidentification?
If all 20 markers match, and they don't always, because sometimes crime scene evidence doesn't have all 20 markers. If they have to have at least 9 to go into the database.
Okay.
But if all 20 match, and a lot of times there is 20. In my daughter's case, she fought so hard for her life that she had that DNA under her fingernails, and blood will give you all 20 markers. So there was a 20 marker match. If all 20 markers match, the odds are 1 in a quintillion that it's not that person. And the quintillion is a number 1.
Or that it is that person.
Yeah, that it is that person.
Okay.
That it's not another person.
Okay.
I'm sorry. And that's a number 1 followed by 18 zeros.
Okay.
And then they have probabilities for the number of the markers that do match. And when they testify in court, when the DNA lab testifies in court, they will tell how many markers matched and what the probabilities are. So they don't say this is this person. They say it is the probability based on these numbers of markers matching is this amount.
Okay, thank you.
Senator McKinney.
Thank you. How would this work for individuals that are looking to be exonerated? Would they have the petition to put their DNA into the system? How would it work? Or how has it worked in New Mexico?
Well, we have had, that I know of, we've had 3 people in New Mexico that were exonerated directly as a result of arrestee testing, DNA testing. And I know of several others around the country. No, they don't petition. What happens is the crime scene evidence remains in CODIS forever. The crime scene evidence cannot be expunged, the evidence from the crimes. So there's evidence from crimes that happened 25 years ago easily in CODIS. CODIS has been live for 23 years. It went live October 13th, 1998. But that crime scene evidence always stays in there. So what happens is someone's arrested for a crime, they swab their cheek, they put it into CODIS, and it matches a crime where there's somebody sitting in prison. And they say, oh, it looks like we have the wrong person. And this has happened a number of times. James Tillman, that Senator Hilkemann spoke about, was in prison for 18 and a half years, wrongly convicted of rape. And he was convicted on erroneous eyewitness identification. And he started petitioning very early to have the DNA run, and it took a long time to have it done. Well, we found out that if arrestee DNA had been the law in his home state, the person that actually did it was arrested 6 years after he was in prison. Now, 6 years is too long to be in prison wrongfully convicted. But he would have been out 12 and a half years sooner because of arrestee DNA, because they arrested the person who was not convicted for the crime. But they do run it through. And if that had been the case, he would have been out of prison 12 and a half years sooner. So that's how it works.
Thank you.
Senator Brand.
Thank you, Chairman Lathrop, and thank you for your testimony today. So could you enlighten me how many other states have a state CODIS system, and Senator Hilkemann touched on the cost on what the cost runs. And to me, the cost is sort of a one-way street. We measure the cost. There's a cost going into this thing, but in a sense, there's also a cost savings if people are apprehended.
Every state has a state CODIS system. CODIS stands for Combined DNA Index System, and the reason it's called that is that every state has what they call ESTIS, the state DNA index system, and then there's a national DNA index system, which is called INDEX. And some states have local DNA index systems called ELDIS, and they all talk to each other. That's why it's called CODIS. But every state has a system. It's been set up, they've all been set up since 1998. That's when it went live. The cost, the national average for a DNA swab of the cheek of an offender is $35. Some places it's a little more, some places it's a little less. But the amazing thing is when I started working on this issue in the fall of 2005, the national average cost was $85. So it's come down substantially. And as Senator Brandt said, what's really amazing is there have been several studies done. One was done by the University of Virginia by Dr. Jennifer Doliak, and it's an independent academic study, and she made many conclusions about arrestee DNA, all very favorable, but one was that for every CODIS profile in CODIS that costs national average of $35, ultimately $27,000 is saved. And if any of you would like to email me, I'll give you my card. I can email you that study because that's just one of the findings. There's a lot of other really good findings as well. The city of Denver did a study under the auspices of the Department of Justice, and their study found that for every dollar they spent on DNA, $90 was saved. And remarkably, it's about the same amount. $30, $27,000.
To follow up on what Senator McKinney, a different form of guess what he was referring to. So just because somebody's arrested, they aren't convicted.
No.
And when I looked at the bill, it appears that there is a way to get your information out of CODIS.
Absolutely.
There's a way to what they, I think Senator Hilkemann can address this maybe, but is it expungement?
Yes.
And so do you have any idea how many people try to expunge their records off of CODIS?
Well, first of all, it's a federal law that if a DNA from an arrest is placed into CODIS, that there must be an avenue for expungement. And also the Office of the Inspector General of the United States inspects every lab annually and does random inspections. Some labs get, randomly inspected more than once a year to make absolute certain that everyone that's eligible for expungement has been fully and completely expunged. I think that's really important because a lot of people think, well, once something gets into the system, you can't ever get it out. This is a very closed system. It's administered by the FBI, and no one can get access. I can't get on and search and see who's in there. It's a very closed system, and they are very, very particular about it. Lots of rules and regulations about what gets in and what gets out and how it happens. But it is absolutely a certainty that if someone is eligible for expungement, that they will be expunged.
And then one last quick question, I guess, is we're testing people 24 hours a day, 7 days a week. Does this update hourly, weekly, monthly? How often do they update a system?
When Katie was murdered, it was once a week. Now it's daily. And they are working on systems called Rapid DNA that will actually be run through CODIS 90 minutes from when the swab is taken. And the reason I know that this fiscal note is a little high is they are working on that. It's about to go live. It's considered very expensive, and it costs about $100 a sample for that almost 90-minute result.
Okay. Thank you.
Okay. I don't see any other questions, but we appreciate you being here. I know you've traveled a long distance, and you feel passionate about the issue, and we appreciate hearing from you.
If you'd allow me, I'd like to make one other point, make one other example.
You may. Go ahead.
The reason it's so important to take it upon arrest and not wait till conviction is that we have many, many, many examples of heinous serial rapists and murderers that have been arrested for a felony, either the charges were dropped for whatever reason or they were pled down to a misdemeanor, and we did not get their DNA. One example is a man named Chester Dwayne Turner in California. He raped and murdered 12 women, and he was in and out of police custody 21 times during that time, and he was arrested, but he was never convicted of a charge that allowed him to have his DNA taken. And when they swabbed him, and it matched to these 12 women that had been raped and murdered, and 2 of them were pregnant, so that's 14 people. They said, oh my goodness, look at this. And what was really, really horrible was there was a man named David Allen Jones that had been in prison for 9 years for 2 of those murders. And he was in prison wrongfully. And that one cheek swab, if it had been taken when he was arrested the first time, would have saved 11 women's lives, and David Allen Jones would never have gone to prison for that.
You know, when you tell that, I can't help but think that David Allen Jones, or whoever this guy is, was sitting in prison and the law enforcement had DNA that didn't match his.
That's possible. I don't know.
I mean, that's the only way this works to exonerate somebody is if they're sitting in prison, there's DNA on the victim or at the crime scene that doesn't match the guy that got prosecuted.
Well, I can tell you another situation that happened in New Mexico. A little girl was raped and murdered, 11 years old, in her own bed. And a neighbor boy, they thought he was involved. They didn't think he did it because the DNA didn't match, but they were convinced he was involved because he knew so much about her bedroom. And they arrested him, and they put him into jail. And he had several motions because he was of limited intelligence, and they were trying to say he wasn't able to stand trial, but he was in jail all this time. And then a man was arrested for burglary in New Mexico, and under Katie's law, his cheek was swabbed, and they got the match. The interesting thing was, he was here illegally. His name was Israel Diaz. The innocent man was Robert Gonzalez. He was here illegally, and they were getting ready to deport him when they got the match. And if they hadn't had that arrestee DNA in New Mexico, Robert Allen Jones may or may not have been convicted, but he was already in jail for almost 2 years. And Israel Diaz would have been free to continue to rape and murder little girls.
Right.
So that's the power of this. That's why it's so important.
I can certainly see the potential for getting people exonerated. We have dealt with that in Nebraska. And I was around when Senator Avery got a bill for the convicted, so this would be taken at another step.
Well, thank you so much.
No, it's our pleasure to have you here today. We appreciate your testimony, and thanks for coming in.
And I would ask one other thing. If you have any other questions that come up with later testimony, if I could be allowed, if you could ask me, I would really appreciate it.
Okay.
Thank you so much.
Thank you. Are there any other proponents of LB496?
Senator, I promised you a short one. This is the short one.
Okay, good.
Thank you again, Chairman Lathrop and the members of the Judiciary Committee for allowing me to testify today. Again, my name is Bruce Farrell. I'm the Chief of Police for the City of Wahoo, also the Second Vice President of the Police Chiefs Association of Nebraska. PCAM believes that LB 496 will give law enforcement an additional tool to assist in cold case and violent crime investigations. This initial buccal swab under those identified violent crimes will be invaluable. There are safeguards built into the bill to keep DNA samples safeguarded throughout the process, including later destruction. CODIS entries will expand, which will result in more opportunities to locate suspects, as well as exclude, and that I think is one of the more important things, is exclude innocent parties from the investigation. As a result, victims of violent crimes will have more opportunities for prosecution of the offender and the closure for them and their families in their process of healing. We'd ask the committee to forward this legislation to the floor, and I'm happy to take any questions.
Senator Brand.
Thank you, Chairman Lathrop. Thank you, Chief. You have sort of a mid-sized police department, in my opinion, because I'm from a rural area. Do you use CODIS a lot in testing? And I mean, does the science that we see and know happens, and you worked in Omaha all those years, does that happen down on the level in our smaller departments?
It certainly can, especially when you have older cases that where collection of evidence would have been before DNA or before DNA became more fine-tuned to collect or to be able to determine with a better specificity of those crimes. So if we had we have a cold case from 1969 that there is some biological evidence that could be entered into CODIS, and that has been tested. And then if there was a match in CODIS, it would go back all the way to this homicide in 1969.
So in a lot of your cold cases, you've already entered the information that you have available in your evidence?
We have that information available, and then also, I mean, we have enough. We don't have as many crimes, but we do have crimes where we collect evidence, whether they're domestic violence assaults. I remember we've had one where a significant domestic violence assault where we were able to submit DNA to the state crime lab, which took about a year for that to come back. If it was in CODIS, it would have been handled much quicker. Again, nothing against the State Patrol, but it's processed sooner and it's done more quickly on the CODIS level. And we've got a case right now that if we didn't know who the suspect would be, we could enter that into CODIS and we would get a match at the arrest.
But really for CODIS to work, it's a two-way street. I mean, the previous testifier talked about collecting from people that are arrested, but the police agencies have to submit whatever evidence, DNA evidence, whether that's blood or something else,
right,
into the system in order to generate matches.
Correct, and that's done more regularly now than. Like I said, I don't know the circumstances that our previous testifier was talking about, but my guess is that it would have been prior to either the more specified DNA, where now we can do mixtures and we can separate multiple suspects out from, and especially on trace DNA that we weren't even able to do 2, 3, 4, 5 years ago. So yeah, you're right. Once law enforcement enters that into the system, it gives us a much better opportunity to solve those crimes.
Okay, thank you, Chief.
I don't see any other questions. Thanks. Oh, I'm sorry, Senator Geis.
I was just looking for your testimony again, so, oh, there it is. You indicated that you would only take, I think this is yours, a swab from people who commit an identified violent crime. And my question is, if you only take it from people who have committed those crimes, what about the people who are doing a lower level crime who may have committed a more violent crime? And if you miss swabbing them, are you following what I'm asking?
Sure.
Okay.
There is that risk. But there's a greater likelihood of the violent crime offender matching in the database for another violent crime, even if it's graduated over time, than someone who's a shoplifter who's all they do is shoplift.
Right, right. Okay,
We're just missing a lot more
Frank, we can't.
with the violent crime offenses, with just the arrestees. Again, let's just look at domestic violence. We have a number of cases that get dismissed because the victim is either intimidated into not testifying or is in the domestic violence cycle where she decides not to testify against her significant other. And so we miss those as they come down the line, and especially if they've had other victims in the past.
I guess my concern would be if you only do like a 1 or 2 felony, whatever those classifications are, and if this individual is caught doing something less important or less terrible, and yet was a terrible crime committer, I don't know the words to use, but that there would be a risk of missing because of that.
Sure.
That's my.
And I guess if this bill were to pass, we kind of have the best of both worlds in the sense that we would capture the 20 markers that they're talking about in the DNA for the violent or crime arrestees. We would hopefully catch on the back end the 20 alleles for people who were less violent that were actually convicted and sent to the state penitentiary system.
Okay.
Again, it's better, I guess, better than not.
Better than not. Yeah. Okay. Thank you.
You're kind of playing the odds, aren't you?
Yes.
Instead of spending money on the shoplifter, we're just going to spend money to swab the people that are involved in more consequential felonies.
And again, I think the odds are that the tendency is most of our nonviolent offenders stay nonviolent. It doesn't always hold true, but if you have somebody who's a shoplifter, they really aren't involved too much in going out and committing homicides.
Okay. I do not see any other questions, but thanks for being here once again. Any other proponents? Any opponent testimony?
Good afternoon. My name is Spike Eicholt, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Defense Attorneys Association in opposition to the bill. I just want to say a couple of things so the record's clear. We already collect DNA in Nebraska for every person who's convicted of any felony. Violent, nonviolent, any felony conviction, DNA is collected as part of sentencing and is sent to the State Patrol and is uploaded to the CODIS National Data Bank. We have a process in Nebraska where a person can be, who is not convicted of a crime, can have their DNA taken from them. It requires a prosecutor to file a motion and show to the judge that there's probable cause to believe that person is a suspect in a crime, and that's at sections 293301. We already have it, and this should not be, I would respectfully submit, marketed as an exoneration bill. We have an exoneration act. It's at 294111 and on that provides for people who are in custody who are seeking to contest the legality of their detention and conviction to request DNA testing. And that was something this legislature has done, as Senator Lathrop mentioned earlier. What this bill would provide for would be the automatic collection of DNA samples for people who are arrested for some designated offenses. Senator Hilkemann is right. This is a narrow version from what he brought a few years ago, because I think at the time it was all felonies, but this is a list of designated felonies. The U.S. Supreme Court did approve of a law similar to this in Maryland versus King, but that was a little different. In Maryland versus King, and it's important, I think it's an important distinction for that 5-4 decision, in the state of Maryland, after someone was arrested for one of these designated offenses, the DNA sample was collected at the time of arrest. A profile was identified, but it was not uploaded into any database, state or federal, until a judge found probable cause to believe that that person had committed that crime of violence for which they were arrested upon. We don't have that process in Nebraska. In other words, this would allow for the collection of someone's DNA at the time of arrest, and they are convicted of some insignificant misdemeanor charge later. Or, and this is why I would submit that the expungement provisions in this bill are really illusory, even if the charges are all dismissed, but the statute of limitations does not run for one of these or other crimes. As you know, as I've testified against this before, we have a whole series of felony offenses, including sexual assaults and other crimes, where there is no statute of limitations. And similarly, the bill would provide that someone is not entitled to an expungement if any conviction whatsoever results following the arrest, and all charges are not all dismissed. So I'd argue that's not sufficient. Other states have this, other states have, but the courts will order that they are expunged rather than leaving it for someone to make the request somehow, or it's done automatically. And here, presumably, someone would have to make some sort of request to the State Patrol. I don't know if that's a court action. It doesn't delineate whether the state is entitled, the prosecutor's office, or entitled to have notice, or the law enforcement agencies are entitled to have notice of this. So I'd argue that for a variety of policy reasons, this bill should not adapt. I mean, ultimately, what this comes down to is balancing individual freedom versus government intrusion, and we would argue that this bill goes too far.
So let me ask, go ahead, Senator Brandt.
Well, real quickly, you said that, Mr. Eichhold, thank you for your testimony, but you stated that if it was a misdemeanor, they would get swabbed, and in the bill, it's very specific, crimes of violence, and we take a whole page here to list, these are not misdemeanors listed here. Am I missing something?
You are right. These are a series of felonies that are listed, but that's when the sample is collected, and that's when it's uploaded to the CODIS database. A person can request on page 7 of the bill that, and presumably this is the State Patrol, that they may request expungement for the reason that they were not charged with a crime of violence.
Right.
Right? So
Yeah.
they were arrested for it, not charged. The collection is done at the time of arrest.
At the time of arrest for a violent crime.
Right.
Yeah, not a misdemeanor.
Right.
Okay, I just wanted to clarify that.
The bill further provides on page 7, lines 18 to 19, that all criminal charges need to have been dismissed with prejudice. So if somebody has, say, a meth pipe or a marijuana pipe in their pocket, they're arrested as a suspect for a first-degree assault or a sexual assault or a burglary or some similar crime that's a designated category offense. But not all charges are resulting. They get a marijuana ticket, they just plead to it. They're prohibited from requesting expungement. That's why I would submit that it's not as robust as perhaps other states' expungements provisions are.
But could Senator Hilkemann amend that to address that specific issue? I mean, that's a very specific issue.
He could. Obviously, he could. But again, I would just remind everybody, we have DNA collection on conviction every felony. And admittedly, we testified against that. We lost that battle. But you already have thousands of people's DNA annually getting collected. The reason the fiscal note is so significant is the State Patrol, not me, not my clients, estimate 5,000 submissions a year based on the designated listing, which are 20 or maybe so offenses for arrest.
But is your argument it's an invasion of privacy? Is that the argument of the ACLU?
Yes. I mean, ultimately, this is, even though it may be restricted access, it is a government database. And I understand that cases can be solved, but that logic extends beyond this felony arrest. That extends for every arrest. That extends for getting a driver's license. That extends to the horizon. If you want to read the Maryland versus King, read Justice Scalia's really strong dissent where he talked about how this is different than a photograph. Something I walk around in public, I don't disguise how I look. I put that out there, but I don't give my DNA profile to people. It does matter. It has personal significant value that is beyond just fingerprints or a photograph.
All right, thank you.
So let me see if I understand. The U.S. Supreme Court took up the Maryland statute that was similar but not exactly the same.
Right.
What was the challenge to the Maryland statute? What was the basis for the challenge?
It was a Fourth Amendment. It was a seizure of evidence without probable cause or without a warrant.
So is this bill distinguishable from the Maryland statute which was affirmed?
Yes.
Or sustained? In what respect? Well, let me ask this first. Do you think this is constitutionally suspect, this particular bill?
I would think so. I know other states, some are very similar to Maryland and with the prison provision, which I think is critical, and some other states aren't, but I don't know if they've been challenged or I haven't researched that. But this, I'd argue, is distinguishable from the Maryland law. The Maryland law provides that when someone is arrested for a listing of violent offenses, which admittedly are similar to those designated here, once taken, a DNA sample may not be processed or placed into a database until the individual arraigned, and it's at that point the judicial officer, which is some sort of magistrate, ensures that there is probable cause to detain the arrestee on the qualifying serious offense.
Okay, so let me stop you there. In our process, we generally would arrest somebody and then they have a preliminary hearing to determine if there's probable cause to hold them and have them tried in the district court.
That's right.
That hearing, for those of you that aren't familiar with the process, generally happens in county court. It can be waived, frequently is, but otherwise there will be a sort of a mini trial with hearsay and all kinds of evidence,
right.
Enough to have an independent county court judge make a determination that there is probable cause to believe the person committed the crime, and then it is moved up or over in Douglas County
That's right.
to the district court for a trial. This would comport with the holding in Maryland, or the statute would be no different than Maryland if we provided that the sample can be taken but not placed into the database until after the person has been had their preliminary hearing.
Or
really
some
don't
sort
use
of
grand juries here, but a
Right.
preliminary hearing, a determination is made that there's probable cause to believe they committed the felony, and then we would be on all fours with the Maryland statute if we waited until after that determination is made to put it into the database.
That would make it similar to the Maryland statutory process that was upheld by the Supreme Court.
Okay.
That's
I'm just asking the constitutional.
That's right.
You're making two arguments.
Right.
One is there's a constitutional problem with it, and the second is it good policy to
Right.
just start swabbing everybody's cheek, even though they may not be convicted of the felony they were initially charged with.
That's right.
Okay, I think I get it. Senator Slum.
Thank you, Mr. Chairman, and thank you, Mr. Eichholt, for being here today. So, what in your mind is the distinction? I get the differentiation between a mugshot and a DNA sample and a cheek swab. We fingerprint those that are arrested and booked in the state of Nebraska for just about anything. It doesn't have to be just for a serious felony. That's not something you publicly display. I don't walk around with my hands up showing the world my fingerprints. Sometimes we strip search those who we arrest. How is any of that different or beyond a simple cheek swab that has 20 non-identifying markers in it?
The strip search is easy because that's not done in public, that's not shared with anybody. The more difficult thing is, and you're right, perhaps it is just a matter of degree between. I think the photograph is easy. Until recently, we weren't wearing masks, right? So when I go around in public, I make myself recognizable to others. I hold myself about who I am. I say who I am. That's different. Fingerprints, a little bit different, but maybe that's just been with us so long, we've just gotten used to it. But I think that the swab, at least the way I understand it, and I think you had somebody testify that knows about it more, you give the sample, the swab sample, it's analyzed by a DNA lab tech. They've got a way that they can look at the nuclear DNA and identify certain markers or repeating alleles that are on there, and they have different ways to do that, either 16 or 20 or 13 or whatever it might be. Everyone's got a numerical code, and that's what's uploaded in there. So the earlier testifier said it's right. My name's not associated with that, but that is a profile that's out there, compiled by a government agency, kept by that government agency, updated regularly and compared to other profiles that have been collected in various parts around the country. I mean, at some point we do live, at least hopefully, in a free society where the rights start with the people and not with the government giving us permission about what we can have and what we can share. And I think that's just a fundamental philosophical difference than just a photograph.
Sure, but we have databases of fingerprints as well, though, right?
That's true. We have a massive amount of government databases for fingerprints, for photographs for that matter, and as you probably know, we've got that digital way of sort of the algorithms of different software programs can recognize those. But this is adding to that existing problem, at least what I would submit as a problem, that existing phenomena where government just assembles all of this data about people, always.
Do you consider rape kits to be an unnecessary collection of data?
No, I don't think that's it. The government obviously has an interest in pursuing crime and pursuing people who commit crimes and holding those people accountable. I understand that. I'm not arguing that. This is not a get away with it argument. At least I'm not trying to make it so. But I think ultimately people are entitled to be private, personal. For instance, people can give DNA samples. I've represented probably 36 people in my time that have been suspected of a crime, they've been arrested on something else, and they've agreed to give a DNA sample. Sometimes it didn't work out very well, but most of the times they do that, right? They give that sample, and you can do that. That's the personal choice that you have. Being arrested, and people are falsely arrested for crimes. You heard about some of the people who not only falsely arrested for some of these earlier rapes and so on, but in prison for years. This would provide that they can have their DNA information collected, kept, and stored.
Sure, and I think the proponents of the bill made a great point as to how that could help those who may have been wrongfully convicted. I think we just disagree on a basic level with the gray area of what's acceptable and what's not, so that's okay. Thank you.
Okay, I think that's it. Well, let me ask this question. Does the fact that you have to do something to get yourself off of this, so I'm charged with a felony, they take a swab, and now I got to jump through a hoop, file whatever motion or whatever process is involved, does that change any of this?
Yeah, I think it does, because if you look at the current expungement now, it just provides for the person who requests from the State Patrol that their conviction has been reversed and the case is dismissed. When you start adding the other ways to get the expungement, I think it's more than just asking the State Patrol for it. In other words, if Douglas County attorney is sitting on a possible charge with this guy and they don't want to let him know that, they may want to know that the guy's requested, and they are not entitled to be notified under this provision. And it's not really, there's not an opportunity as far as I can tell to have a hearing to make your pitch. It's just presumably something that you just request to the State Patrol. And
so a letter to the State Patrol, I wasn't convicted of that felony, take me out.
Yeah, and that may seem easy, but I don't know if that really is something that this committee and that body want to have happen. Why would you want to let that happen? You want to maybe let the law enforcement agency that collected this DNA sample know, maybe the prosecuting entity somehow know, and maybe if it's going to be a fight about it as to whether all charges were in fact dismissed or whether the statute of limitations had expired or whatever the other grounds might be, it would probably make more sense to have it as a component of the criminal case, which the Maryland statute had and some of the other state laws have.
Okay.
That if, in other words, if the judge, and I'm just stringing these out, if the judge at a probable cause hearing, preliminary hearing, found no probable cause, they could further order that any DNA sample collected at the time of arrest shall be expunged or something similar.
Okay. I don't see any other questions, but thanks for being here. Any other opponents to LB496? Anyone here in the neutral capacity? I see none. Senator Hilkemann, you may close on LB496. We have two letters, position letters. Both letters are proponents or from proponents. We also have written testimony from Corey O'Brien with the Nebraska Attorney General's office, which testimony is a proponent.
Thank you for listening to this very important topic. In answer to the question whether this has been challenged constitutionally, I believe it has been. I believe it's been upheld every time it's been challenged. And I will ask, I didn't get a chance to ask JM, but I believe that that's correct on that. And then the expungement, if you go to the 7th page of the bill, it's very clear how the expungement occurs in this bill. And then, Senator Slama, on your question, thank you for that. You know, I understand that in Lancaster County, if you're arrested for a felony, your picture appears in the paper. And I think I would rather have 20 of my DNA markers that no one else can see rather than have my picture in the paper. But at either rate, I'm going to end with a personal story. December 23rd, 1998, David Allen Stevens was brutally murdered, burned beyond recognition in his car in La Jolla, California. David Allen Stevens was my second cousin. His murder went for a long time before it was finally solved. It was actually solved from Unsolved Mysteries, an episode that they ran of it about 8 to 10 years later. I saw what it did to my cousin, not knowing what happened to their 20-year-old son. If we can do anything to help with stopping those crimes and preventing other people from going through through the pain and the suffering. I know that I shared that it took my cousin's life sooner because we were so obsessed with trying to find out who murdered my beautiful son. This gives law enforcement one more avenue to try to help stop, prevent, and determine who is the perpetrator of the crime. I ask you to advance 496, and I would answer any additional questions you may have.
Okay. Any questions for Senator Hilkemann? I don't see any. Thanks for bringing this very interesting bill to the committee. And
Senator, I'm going to say one more thing, and this is in relationship to the Maryland thing. But this whole thing is about whether we do this after the arraignment or not. I like the bill the way we have it. But if we have to discuss things like that, I'm willing to work with it. This is that important to me. And I think it's important for the people of the state of Nebraska.
okay. I will say this, that just as from a lawyer point of view, you get an opinion from the United States Supreme Court, that's the last word on something. Then lawyers try to say, well, is it distinguishable from the case that they decided in Maryland? The closer your bill is to the statute in Maryland, the more authoritative the opinion is, and the less it can be distinguished, or the less the likelihood is that it can be distinguished from the holding in the Supreme Court. That's the only reason we ask those questions.
And in my visiting with Jay Ann about this earlier today, you know, this is in 31 states already, and you know, there's probably not any one of those bills exactly the same, and we can work together to get, we can accomplish what we want to accomplish, whether it looks exactly like what are the other states.
Okay.
But I want us to move forward on this.
Okay.
Thank you.
We appreciate it, Senator Hilkemann.
Thank you.
Have a great weekend.
Thank you.
That will close.